Curtea De Apel Bucharest, Romania against Popoviciu.
Yes. Please, my lords, I appear with my learned friend Mr. Miller for the appellant, my learned friends Mr. Fitzgerald, Mr. Caldwell, Mr. Hall for the respondent. I hope it will assist, my lords, if I outline at the very beginning a roadmap of the submissions I intend to make.
Before we do that, perhaps we should address very briefly the various supplemental bundles that have come in. The court is not going to ask parties to take up time on this. The court's position is that we are prepared to look at the material de bene esse, but we have to say that we do not see how we can resolve a question of Romanian law, which is a question of fact, which is disputed without the witnesses being exposed to cross-examination. So we will look at the material, but we have to warn you that we do not think that we will be able to make any resolution of that matter.
I hope it'll be of some comfort to my lords to learn that my position will be you don't need to make any determination of that materials to determine any issue in this case, and if you did, the core agreement between the parties would be sufficient to move forward. But I'll
Yes.
come to that at the appropriate point. But for now, we can put aside the slightly chaotic supplemental materials that have arrived during the cast of.
That is fine, but I thought it was fair to give you notice of.
I'm grateful, my lord.
Of what the court has already discussed internally.
And reciprocally, can I therefore give you notice of the submissions that I plan to make and the order I plan to make them? First, my lord, I will start with explaining why, in this case, the error of the High Court cut far deeper into the fabric of the convention than merely tampering with the standard of proof. What it did was materially different to that. Next, my lord, and for the remainder, I will assume that the respondent's position is right and that this case is indeed all about the standard of proof. And we will look first at the two essential facts to be proved in an extradition conviction case under Othman, namely Article 6, past violation, Article 5, future risk of detention as a result. And I'll look first at how the domestic law would approach both of those problems by reference to Pierce and Shagang shipping. And the answer we will see is that for the Article 6 backward-facing question, there can be no question of proof by reference to any standard less than the standard of proof that is set. Thirdly, then, we will look at what the standard of proof actually is. And we'll look first at the conventional domestic approach to proof of past facts, applicable or capable of forensic proof, where standard of proof is always the balance of probabilities. And we'll examine whether Strasbourg takes any different view. And what we will see is that the standard of proof Strasbourg always applies to past facts is beyond reasonable doubt, except, of course, in respect of torture. And we'll look at the policy reasons why Strasbourg insists on beyond reasonable doubt as the appropriate standard. Fourthly, we will be unsurprised to see that domestic extradition case law follows the same path. We would call it balance of probabilities, but it means essentially the same thing. Next, fifthly, we'll look at Rostas, the Irish case, and see how it arrived at the erroneous result that it did by misreading Othman. Sixthly, we'll look at Strasbourg's approach to torture evidence and examine why in that unique context, and only in that unique context, Strasbourg is prepared to countenance a standard of proof less than beyond reasonable doubt. And we will see that the rationale that lies behind that is one that cannot be applied more generally. And in the course of that, we will look at how Strasbourg approaches cases where the facts to be proved lie within the knowledge of the state. We will look at the law surrounding inferences in that context. Seventh, we will see that there is no special rule for bias, and we'll explore why that is. Eighth, I will deal briefly with the respondent's suggestion that Strasbourg, in fact, operates no burden of proof, and therefore no standard of proof at all. Ninth, we will review the relevance or otherwise of the absence of a future remedy in Romania to the respondent, so far as the issues that we will have been discussing up until that point are concerned. And then lastly, 10th.
I'm sorry, your ninth point again?
Sorry?
Your ninth point?
Ninth will be absence of future remedy and how that plays in
Thank you.
to the Othman questions, the two facts that have to be proved. And then 10th, my lord, I will finally address the new alternative case now being advanced by the respondent, that the absence of remedy separately shows a future prospective violation of Article 5.4 of the Convention, that is, a right to review by a court of the legality of detention by reference to changed circumstances. And it's there that we will need to look briefly at the fresh evidence, if we do at all. So, my lord, can I start with my first proposition, and that's that this case isn't about the standard of proof at all. The core error, my lords, of the High Court's reasoning was not simply in adjusting downwards the standard of proof, which regulates the quality of evidence required to show past fact. But what it did was much more fundamental than that. What it did was tamper with the ultimate fact to be proved, and thus remove altogether, in fact, the requirement to show past fact of Article 6 violation. Can I invite my lords to take up the High Court's judgment, electronic page 196, paragraph 154. The test that the High Court laid down for past Article 6 violation is first enunciated in lines 4 and 5 of that paragraph. Substantial grounds for believing that there was a real risk that the requested person's trial had been flagrantly unfair. That's the test. You take a coloured pen and draw a vertical line after believing that. To the left will be the standard of proof. Everything to the right is the fact to be proved. A real risk of a flagrantly unfair trial is, on the High Court's view, the fact to be proved. The level of proof, or the degree of persuasion required to achieve that, is substantial grounds for believing. Now, that may be appropriate in an accusation context, where the event in question hasn't occurred and may never do. But it is unarguable that that is wrong in the conviction sense of assessing an Article 6 violation constituted by past facts. The standard of proof, substantial grounds for believing, frankly doesn't matter. It could have been set at absolute certainty, but the result of adjusting the fact to be proved still means that all the court would have to be satisfied about, to whatever standard, is a mere risk. There is no support whatsoever anywhere in the Strasbourg case law for real risk of something happening as the fact to be proved. The case law is completely clear. The fact to be proved in any conviction case, in any convention context, is that the trial was flagrantly unfair. Searing, paragraph 113, electronic page 2730.
Sorry, page again.
2730, my lord.
Thank you.
Makes this abundantly clear. What needs to be proved to engage Article 6 in the extradition context is proof to whatever standard, and it may or may not be clear from the Searing judgment what the standard of proof is, but proof to whatever standard that the defendant has suffered a flagrant denial of a fair trial.
Which paragraph are you?
113, my lord. 2730. This is the original fountain of
Yes,
this area
yes.
of the law. It's been cited repeatedly since. It's dealing with both sets of cases, a future-looking accusation case, a backwards-looking conviction case, and it drew a clear dichotomy between the two. In the conviction case, what needs to be shown, the fact to be proved, to whatever standard, is has suffered a flagrant denial. It could have said, had it meant something else, the fugitive is at real risk of having suffered or risking suffering an unfair trial. It doesn't do that. What the Strasbourg court does here is clearly set down in a conviction case, the fact to be proved as has suffered. And it's been repeated as such innumerable times since. Or else, the test has been paraphrased. So, my lord, if one turns to Drost, paragraph 110, so that would be electronic page 2396, dealing with a conviction case. So not having to concern itself with the dichotomy. In a prisoner transfer context, so following a conviction, but what has to be shown, and again, to whatever standard, and we'll return in due course to see whether the Strasbourg court in these cases articulates the standard, but what has to be shown, last two lines of paragraph 110, is that the conviction is the result of a flagrant denial of justice. The fact to be proved unambiguously is that the trial was unfair, flagrantly unfair. I have no doubt at all that I will miss out the term flagrantly throughout my submissions, and that's only because it's not in issue in this case. So where I say unfair, I always mean flagrantly unfair. But the fact to be proved is that the trial was flagrantly unfair. And Drost, like Searing, has been acted on time and time again. There is no departure in any European case from that requirement in the conviction context to show as the fact to be proved that the trial was unfair. Reasonable risk that the trial was unfair has never been suggested by Strasbourg as the fact to be proved in any conviction case. And crucially, my lords, even in the special context of torture evidence in Hoffman, the Strasbourg court did not adjust the fact to be proved in the way that the High Court did in this case. So can we look at Hoffman? I think probably paragraph 273 at page 2608 will suffice for these purposes.
Sorry, page number again, sorry.
2608, my lord. In this context, in this special context, to which we will have to return, the test that the Strasbourg court erected for proof of past fact of torture was real risk that the evidence was obtained by torture. Real risk is the standard of proof. Was obtained is the fact to be proved. It did not, even in that extraordinary context, adjust the fact to be proved. Torture was obtained, the evidence was obtained by torture. Conversion...
Sorry,
Sorry.
difficulty in relation to the Porter against McGill test, which isn't necessarily the autonomous test applied in Strasbourg, but you have two stages. You find out, first of all, what the circumstances are, and then you form an evaluative exercise in relation to those circumstances.
Yes,
and so one doesn't say that one has to... the flagrancy of the breach isn't a fact. It is the evaluative exercise that is carried out after you've established that a judge, for instance, is corrupt.
Yes, I accept that. In the bias context, in the Porter and McGill context, you would need to establish the core facts to the usual standards of proof, and then you apply the legal test for bias to those facts.
Does the Strasbourg court apply Porter against McGill, or is there an autonomous concept?
The Strasbourg court approaches this all in exactly the same way. Save in respect of torture, where the standard of proof is lowered, in all cases across the board, including in torture cases and including in bias cases.
Does the Strasbourg court have a two-stage test?
No, my lord.
No. It is...
Defines the facts, and then it applies those facts to the legal test, whatever it is in the context in question. But my point about Othman is that even in the torture context, and even where the court is prepared to move the standard of proof, it has never countenanced moving the fact to be proved. And conversion in this case of the fact to be proved should have been trial was unfair into a different and lesser target, real risk that the trial was unfair, was indefensible. It cuts across all the Strasbourg jurisprudence. It cuts equally across the English jurisprudence in this area. See Leson, paragraph 22 at page 1730. I'll return to that case a little later. 1730, my lord. There is no conviction case where the fact to be proved is presented as a real risk that the trial was unfair. And the respondent cannot, and in the end will not, attempt to defend the conversion of the fact to be proved in that way, which makes it unnecessary to explore all of the underlying reasons why Strasbourg has never and would never convert the fact to be proved in that way. It would lead to a different fact to be proved, a lower fact to be proved than applies in the domestic context. It would invert the operation of the convention as it works in the foreign context. The respondent's argument in this case is different. The respondent's argument now is that the High Court was using real risk in a different sense. The respondent's case, one goes back to judgment paragraph 154, is that you should draw a line instead after the words risk that.
What's the page?
Page 196 in the electronic papers, my lord. So we're back to our core test laid down by the High Court, substantial grounds for believing that there was a real risk that the requested person's trial had been unfair. As the respondent reads the judgment, everything to the right of risk that is the fact to be proved, and it's conventional. The trial had been unfair. And everything to the left is the standard of proof. Well, that's, with respect, difficult to understand. It would mean that there are two standards of proof: substantial grounds for believing that there was a real risk that the fact to be proved is established. That is, in our respectful submission, incoherent. You can't have two cumulative standards of proof. A low standard of proof multiplied by a low standard of proof is an even lower standard of proof. A 20% chance that a 1 in 3 risk will eventuate equates to a 6% chance that that event will occur. It doesn't make grammatical sense, and it's not what the High Court believed it was doing. The High Court believed that it was adjusting the fact to be proved. You will not find the word standard of proof in this judgment anywhere. It was invited to adjust the fact to be proved. See paragraphs 147 and 148 on page 195. The appellant submits, that's the respondent below, is sufficient for him to show to some unspecified standard of proof that his conviction may well have been the result of a flagrant denial of justice. The real risk, given the shorthand there may well have been, is being treated as the fact to be proved, not the standard of proof. And that's precisely what the High Court then did. Back to paragraph 154, what it sought to do, as it explains, my lord, at the end of paragraph 154, is to assimilate and use the test as it applies in an accusation case. That had been the submission that the respondent advanced, that it was a reasonable counterpart to the accusation test. And as it works in a future-looking accusation case, it is abundantly clear that the fact to be proved in that case is real risk. You can see it, for example, my lord, in the Court of Appeal's decision in Libya, AS Libya. So 2907. In the accusation context, real risk is being used in the sense of fact to be proved, not standard of proof. See paragraph 24 at 2907. Substantial grounds for believing that there would be a real risk.
Sorry, where in 24?
Paragraph 24 at page 2907.
Yes, where in 24?
It's just before the quotation.
Sorry, it's the first 4 lines of paragraph 24 of the AS Libya judgment. Substantial grounds for believing that there would be a real risk. That's the test that applies in the accusation context. It means no more than there must be a proper evidential basis for concluding that there was a real risk. A risk there is a question of fact. Either it exists or it doesn't, and the standard by which you have to show it is substantial grounds for believing. That is the test that the High Court sought to implant into the conviction context.
Yes, in that paragraph they look at Saudi and Italy.
Yes.
Yes.
That was another accusation forward-looking.
Yes, because you can see there evidence capable of proving that there were substantial grounds for believing. Yeah.
Well, it's easy to descend into semantics, but what that means is evidence capable of establishing substantial grounds.
Yes.
For establishing, that's the standard for establishing fact to be proved real risk. And at paragraph 50 of the AS judgment 2916, Court of Appeal makes the elementary fact that risk is a question of fact. It's the fact to be proved in the accusation context. And by lifting that test and trying to transpose it onto the conviction context, what the High Court has done is transpose the fact to be proved. It's changed it from was the trial unfair? Have you shown to whatever standard of proof that the trial was unfair? To have you shown to whatever standard of proof that there's a real risk that the trial was unfair? And that, my lords, is a fundamental error. As I said at the outset, it doesn't matter if that is what you have done, but where you set the standard of proof, the damage is done, and it's indefensible. The High Court has selected and addressed the wrong fact to be proved. What the respondent should have been required to adduce evidence to show to whatever standard was that his trial was unfair, not evidence to show that there's a real risk, or may well have been. It's plainly wrong, and the High Court's decision falls to be set aside on that elementary basis. And I have to say, we've given careful consideration as to whether or not we can just sit down now and rest our case. But what
I suspect you're not going to.
No. What we propose to do in the remainder of our submissions is to address this case on the basis now advanced by the respondent, namely that the High Court was using reasonable risk as a standard of proof. It's not what happened, but let's address it. Not least of all because having returned the law to its correct course, namely fact to be proved is trial was unfair, we anticipate the court may wish to say something about the correct standard of proof applicable to that exercise. So what I propose to do for the rest of my session is to don sunglasses and assume that the High Court is using real risk instead as a standard of proof, and that substantial grounds to believe was mere superfluous wordage that we can just delete. Of course, at any stage in what follows, we could all just remove those sunglasses and remind ourselves that that isn't what the High Court did at all. It was never using real risk as a standard of proof. It was doing something far worse, which is adjusting the fact to be proved.
Is the word flagrantly evaluative?
Yes.
Right. How do you prove a fact where you have an evaluative judgment based on other facts?
My lord, the core facts need to be established
Yes.
to a standard of proof.
Yes.
From those core facts, one then can engage in the applicable legal test. So my lord, we'll come to it in due course, but the Pierce usage of facts in issue, in that scenario, your core fact would be the unfairness of the trial, and flagrancy is then the legal test that's applied to the assessment of those facts.
Okay, but you said that the divisional court had changed it from was the trial flagrantly unfair to was there a real risk that the trial was flagrantly unfair.
Yes.
You have assumed that there was a fact to be proved which involved an evaluative judgment.
But it's not the same as, I understand that my lord would be concerned with the word flagrancy and how it should be approached, but it's not an evaluative, forward-looking assessment of future risk. It is.
I'm just questioning whether it is a fact. You say you can sit down because what they have done was changed the fact to be proved.
They have, my lord.
But the fact to being proved, on your definition, includes the concept of flagrancy.
Yes.
And that's evaluative.
Well, it's evaluative in a sense. A past violation of Article 6, once you have established your facts, is or isn't flagrant. It's a legal test. And the facts will either satisfy it or they won't. So it's not evaluative in the sense of assessing whether a risk exists in the forward-looking sense of, or whether it's something likely that something might occur in the peers sense. It has an evaluative assessment in it in precisely the same way as all legal tests have some evaluative assessment to it. But it isn't. It doesn't affect the way you look. It doesn't rob the past fact of its status as a fact to be proved.
You say it'd be like gross negligence.
Yes. Yes. Your core facts have to be proved, and to those you would have to determine whether it does or doesn't satisfy the legal test of grossness or flagrancy. That involves some evaluative exercise, as all legal tests do, but it doesn't impact the core proof of the facts. Can I return next on the assumption that what we're talking about here is a standard of proof, not the fact to be proved, that real risk was being used in the sense of a standard of proof. What we need to do, I suspect, is return to the facts that need to be established by a defendant in the respondent's position in a case where somebody is resisting extradition based on complaints about the fairness of the trial they underwent abroad. And what they need to do, and you see this in Othman paragraph 233, so page 2598. A defendant who wishes to resist extradition based on complaints about the fairness of the trial that has already happened needs to establish two things. Firstly, this is paragraph 233 of Othman. Last 8 or 9 words. They need to show, under Article 6, that their trial was or has been flagrantly unfair, such as to engage Article 6 in the foreign context. That's the first core fact.
Sorry, you're reading 233. Where in
233, last line. The test that we are looking at, or that we needed to apply, comprises the last 4 lines of paragraph 233. And it comprises 2 essential facts to be proved. I'm taking the second mentioned first. The first and core fact is that the defendant has previously been convicted after a flagrantly unfair trial. That's a backward-looking, straightforward, factual assessment. But that's not going to be enough to enable somebody to escape extradition. They also have to show, as a second fact to be proved, a real risk of being imprisoned for a substantial period in the receiving state. That is, being exposed to detention in consequence of that flagrant breach, such as to engage Article 5 and to call into question the legality of your prospective detention. And it might be useful to frame those issues in view within the domestic dialogue that this court usually engages with. So we have two separate facts to be proved, or in the language of Shagang Shipping or Pierce, two facts in issue in the case. Historic Article 6 breach and separately a risk of future detention. Looking at the issue through a domestic lens, different principles would likely apply to each. A risk of future detention would conceptually operate in this jurisdiction as an evaluative assessment of future risk. Its purpose is to weed out cases where there might be a retrial or an amnesty or a negligible sentence or a prospective remedy in the requesting state, such as whatever happened in the trial doesn't really matter because you're not going to be realistically exposed to its consequences. And that question, is there a risk of future detention, can of course be informed by past fact. Defendant can say, well, look at this other similar case. There was an amnesty issued in that case. You can therefore infer that in my case it might happen again. On general principles that this court applies, summarised most recently in Pierce, paragraphs 34 to 46, that assessment of future risk can be informed by past facts, even if they haven't been proven to the requisite standard. And that is because the past fact, there was an amnesty in another case, isn't the fact in issue here. It doesn't dictate the outcome of the claim of the risk of future detention. It's merely information which informs that evaluative assessment of future risk. It makes it more or less probable that it might happen. It's the risk that is the fact in issue, not the past fact of an amnesty being granted in some other case. So for the fact in issue in this case, is there or is there not a risk of future detention in Romania? One can, on domestic principles, look at allegations that haven't been proved to the requisite standard of proof. None of that had any bearing in this case, because the Article 5 fact in issue was uncontentious before the High Court. On the facts before the High Court, if surrendered, there is no issue, but that the respondent will be exposed to the consequences of the trial he had. The evidence suggested that he has no local remedy to prevent it. He will serve his sentence. That sentence is substantial. And I don't seek to go behind that evidence in this court for the purposes of that issue, just on general principles of fairness. Even if there is now other evidence available, I don't seek to deploy it for these purposes.
If there is an issue as to the possible remedies that might be available on return to Romania, would that fall into the same category of
Yes.
Assessment of future risk?
Yes, it would, because, and we'll come to this in due course, but the fact in issue is there a risk of future detention? That's an evaluative assessment. It can be informed by other facts, i.e., is there a remedy in Romania? And those facts would be subject to Pierce principles. Defendant could rely on them even if he hasn't established them to the requisite standard of proof. So he could say, well, I haven't established that I don't have a remedy in Romania, But there's still a suspicion that I might not, and that should feed into the future risk evaluative assessment on Pearce principles. I accept that.
Thank you.
That's the forward-looking Article 5 fact in issue. It works in the way that Pearce works, and I don't seek to suggest otherwise. What was, however, contentious before the High Court was the proper approach to the other fact to be proved, the other fact in issue. That is, the backward-looking fact in issue. Has there been a flagrantly unfair trial? On that, the Pearce analysis would work differently. Looked at through the prism of domestic law, Pearce, Shagang, shipping, where defendant alleges historic past violation of Article 6 by reason of judicial bias or corruption, the court will ask itself, what is the fact in issue? According to Shagang shipping paragraph 98, Pearce paragraph 34.
Sorry,
Shagang shipping paragraph 98, Pearce paragraph 34. The essential issue, fact in issue is that which the defendant needs to prove to establish his defence to extradition. Answered shortly for this issue, it would be the fact of past judicial bias or corruption.
You couldn't give me the page numbers for both of those.
Of course, my lord. Shagang 98 is 2231. Pearce 34 appears in Supplemental Bundle 1 at page 69.
Thank you, Wish.
So here, because the fact or otherwise of judicial bias or corruption is the fact in issue in the Article 6 backward-looking question, the law is undoubtedly binary in its operation. Bias is either proven or not proven. It's a fact or a non-fact, according to the applicable standard of proof. There is no room for taking into account unproven allegations. There's no scope for satisfying the standard of proof by reference to something less than the standard of proof. Lord Hoffman's binary rule in Re B is now well established as applicable where the fact to be proved is a fact in issue. See Shagang Shipping paragraph 96, page 2230. It is of course true that where the fact to be proved is a fact in issue in the case, the law operates in a binary fashion. Pearce paragraph 34 again, Pearce paragraph 65.
Sorry, Pearce 60.
Pearce 34, Pearce 65.
Thank you.
In fact, if one looked also at Pearce 42, you would see that principle established clearly previously by Lord Hoffman in a case called Raymond.
That's supplementary bundle page 70 or thereabouts.
That would be 74. Page
74.
Pearce 42 would be page 74 of that bundle. A fact in issue either happened or it didn't. So long as the facts to be proved are the facts in issue, they receive a value of either 1 or 0 in the binary analysis. In this case, the judge either was or he wasn't corrupt. There has or there hasn't been an Article 6 violation. There's no scope for operation of any principle whereby something less than proof can nonetheless be taken into account. So the issue, therefore, collapses, my lords, into a search for the correct standard of proof against which that binary rule operates in relation to the Article 6 issue posed by Hoffman. Has there been an unfair trial? That is the fact in issue. Binary rules operate, or at least would in this jurisdiction. The only question is, what is the standard of proof? Because once you know it, the defendant has to be held to it.
You gave us a reference to Pierce 67.
I said 65, my lord.
65, yes.
It would be 65, subparagraph 1, at page 85 of Supplemental Bundle 1.
Yes,
That's the binary rule. It exists and it operates in appropriate cases, and it would exist and would operate in respect of the fact to be proved in the Othman case. Has there been a past violation? Has there been corruption? So the only question is a search for the correct standard of proof, and it's that to which I turn next. The realistic choice here, my lords, is between balance of probabilities on the one hand and something less, because we never put beyond reasonable doubt in the way we understand it as a standard of proof that a defendant needs to establish. The something less, and the respondent's reading of what the High Court did, would be real risk. As the Court of Appeal observed in Othman when it returned back to this country, that's not an overly helpful conceptual phrase when being used as a standard of proof. It means, in reality, something like real chance or possibility. So your choice is balance of probabilities on the one hand or chance or possibility on the other. But viewed from a domestic perspective, the answer would be very clear. Unlike future predictions, domestic law recognizes that past fact is different. It's capable of forensic proof. And I don't anticipate I need to remind my lords or spend very long on this, but if we look, for example, at an old case, Mallet from 1969, and turn to page 3391. Lord Diplock makes that very point at passages F and G. Assessment of what will be or what would have been is an estimate in, and these are the various words used by the House of Lords in that case, estimate or conjecture, according to Lord Morris, at page 3388. Prophecy and probability, Lord Pearce, 3389. Speculation, Lord Diplock, 3389. What modern judges would label evaluative exercise. But the point of this case is that all of that contrasts starkly with the very different exercise of conventional proof of what was. And this is the point that Lord Diplock makes on page 3391. The view of what will be and what would have been is to be contrasted with the ordinary function in civil actions of determining what was. In determining what did happen in the past, a court decides on the balance of probabilities. Anything more that is more probable than not, it treats as certain, and vice versa. What will happen is, of course, different, and here you see the beginnings of what will ultimately become the principles that are finally espoused by this court in Pearce. When you're looking instead at future risk, It's a different forensic exercise. You're looking at chances, and you can take into account past facts, whether or not they are more or less than evens. In essence, there is a significant difference of approach and principle between future prediction, on the one hand, that's the Article 5 fact to be proved in this case, and past fact capable of forensic proof, the Article 6 fact to be proved in this case. The same point is made in various domestic contexts, and it's probably unnecessary to recount them. 2, the former, proof of what will be or what would have been. The correct standard of proof is less than the balance of probabilities. See Mallet, Lord Diplock in the passage we've just cited. You could also see the same in Fernandez at page 1688 and 89. But to the latter, proof of what was, the approach of this jurisdiction is always that the correct standard of proof is balance of probabilities. See Mallet in the passage we've just looked at. In Fernandez, Lord Diplock termed that proposition trite at page 1688. In Hodson,
whereabouts on 1688?
1688 in Fernandez. Forgive me, my lord. So this is the year later. H, my lord, down at the bottom. It is convenient and trite to indicate a degree of certitude which the evidence must have produced in the mind of the court as to the existence of facts. Balance of probabilities is that passage at the bottom. It's what Lord Ackner in Hodson, a little later on, called axiomatic at page 3198.
Sorry, page?
3198, my lord. Domestic law is absolutely all one way. Past fact, capable of forensic proof, needs to be established on the balance of probabilities. Is there, therefore, any basis for taking the view that Strasbourg has mandated some different approach under the Convention? The answer emphatically is no. And can I headline what it is that the next part of my submissions are going to show? Because we're now turning to Strasbourg. We know what would happen in domestic law. We know under Pierce you would be held to the standard of proof, and we know under Mallet, Fernandez, Hodson, that standard of proof would be balance of probabilities. Does Strasbourg do any different? Absolutely not. 1. The standard employed by Strasbourg for proof of past fact is always beyond reasonable doubt.
Can you help us, please, as to what the Strasbourg court means by that?
Well, I'm going to, my lord, because it doesn't mean beyond reasonable doubt in the sense that we mean it. It means something probably more akin to balance of probabilities.
Yes, it's a concept derived from civil law jurisdictions.
It is.
About being certain.
It's got nothing to do with criminal responsibility. That's the point that the Strasbourg court makes. So it's not set that high, but it obviously means more than 50%. So 1, the standard employed by Strasbourg for proof of past facts is always beyond reasonable doubt. 2, torture evidence aside, Strasbourg has never suggested any standard of proof short of beyond reasonable doubt in foreign conviction cases. 3.
Sorry, you're going to have to...
No, I'm going to come back to these, my lord.
You're speaking up, so it would be useful to let us note them.
So the second, accepted torture, Strasbourg...
Torture evidence aside, Strasbourg has never suggested any standard of proof short of beyond reasonable doubt, and has certainly not done so in the context of foreign conviction cases. 3, where Strasbourg does contemplate a different standard of proof, it says so. And 4, ultimately, the very fact of the exercise undertaken in Othman, setting the standard of proof down at the level of real risk in the torture case, shows that something else, higher, otherwise applies. Can I make good those propositions? 1. The usual standard of proof employed by Strasbourg for...
Sorry, I have to slow down a little bit, Mr. Summers,
apologise.
otherwise I'm not going to be able to...
Yes, you said Strasbourg doesn't do anything different for those 4 reasons.
Yes. Strasbourg does not adopt any different approach to that which would pertain in this jurisdiction, namely balance of probabilities, and you're held to it on analysis for reasons which can be reduced to 4. 1, the standard employed by Strasbourg for proof of past facts is beyond reasonable doubt. 2, torture evidence asides, never suggested any standard of proof short of beyond reasonable doubt in a foreign conviction case. 3, where it does countenance different lower standards of proof, it says so. And 4, ultimately the very fact of the exercise undertaken in Othman shows that something else higher than real risk applies normally.
3 and 4 really is your analysis of Othman.
Yes, 3 is actually a wider proposition, because what we'll see is Strasbourg uses substantial grounds for believing as the appropriate standard of proof in some contexts. We saw it right at the beginning for the future accusation cases, and when it does that, it says so. And we will see that in torture, it uses real risk as the standard of proof. It says so. Proposition 1. The usual standard employed by Strasbourg for proof of past fact is beyond reasonable doubt. There are multiple cases to which one could turn for this proposition. I'm going to start, if I may, with Gafgen. So, my Lords, page 4311. This is a domestic Article 3 case, where the allegation was of a past breach of Article 3 by reason of torture. At paragraph 92, the court says, page 4311, in assessing the evidence on which to base the decision as to whether there has been a violation of Article 3, the court adopts the standard of proof beyond reasonable doubt. We're going to come to inferences and how they inform the standard of proof a little later on. But the core point here is past fact, standard of proof is rigid, it is beyond reasonable doubt.
The second half of that paragraph may be highly material to the case you have to meet.
It might be, and I'm going to come to it when we deal with how the court deals with inferences and how they relate to the standard of proof. But my essential point, by way of headline, my Lord, is that the standard of proof is immutable. It is always beyond reasonable doubt.
But you may satisfy that.
You may be helped to satisfy it by the employment of inferences. And we're going to see how they work. They work in the conventional sense. If you raise a credible case and the facts are within the knowledge of the state, they can be expected to respond, and if they don't respond, that is evidence in its own right. But the core point here, and we're going to see it again and again, is inferences aren't the standard of proof themselves. They help somebody reach the standard of proof. And as they work in this jurisdiction, an inference is an aspect of proof which can give a defendant a leg up in order to establish that which you wouldn't otherwise be able to establish on the evidence. But nowhere are you going to see the line itself, the standard of proof, being lowered or equated with inferences. Inferences and standards of proof are different. The standard of proof is always beyond reasonable doubt. How you meet it is when you encounter inferences. But my Lord's absolutely right. I need to confront the law on inferences, and I will do when we look at Othman, if I may. So my proposition one is, for proof of past facts, the standard is always beyond reasonable doubt. You see it in operation in this case on the facts, for example, at paragraphs 96 to 99. 96, lines 3 and 4, in assessing these allegations, which were contested by the government, whether they had been proven beyond reasonable doubt. Ultimately, paragraph 98, they weren't established to that standard. And 99 was the same in respect of some other past fact. But the law is clear. What is required is proof beyond reasonable doubt. The same applies in Article
98 is quite clear on that, yes.
Forgive me, my Lord?
Paragraph 98
Yes.
is quite clear as to what the test is.
So, well, the test you see, my Lord, in 92 general principles, you see it applied then
Yes.
in 98, and you see the same in 99 if you look at the last line of 99, by reference to a different past fact, but also not proven beyond reasonable doubt. It's what Strasbourg does, and it does it in respect of all articles. So for Article 6, see Semionovi, paragraph 124.
Sorry, again, please.
Semionovi, paragraph 124, page 2646. I don't want to spend a huge amount of time going to each of these, my Lord, but let's just look briefly, please, at that. Semionovi, Article 6, domestic case. Grand Chamber, again. Paragraph 124 at page 2646. The court reiterates under, this is under Article 6, the court reiterates that in order to assess this evidence, it adopts the standard of proof beyond reasonable doubt, but adds, as my Lord Kitchen has observed, that one looks to inferences in order to operate that standard. But the standard remains throughout. And there are multiple other like cases to which we could look. For Article 3, whether prison conditions were good or bad, as an issue of past fact, see paragraph 121 of Ananyev at page 2278.
Sorry, Ananyev.
121, my Lord, page 2278. For Article 5, see Krianga, paragraph 88, page 2336. For Article 10, see Backer, paragraph 143, page 4008. They all say exactly the same thing. The standard of proof is always beyond reasonable doubt when the court itself has to determine past facts. Even the respondent's favourite case, Merabishvili, says this in terms. So my lords can turn to paragraph 314 at page 2481. This is an Article 18 case, so we've seen the whole gamut of potential articles to which proof of past fact might be relevant. Article 3, 5, 6, 10, now 18. Merabishvili, paragraph 314. Second aspect of the court's approach. We'll come back to its first aspect on burdens, with the standard of proof before it is beyond reasonable doubt.
So you say paragraph 314?
314, my lord, at page 2478.
2478.
Sorry, I think I gave you the wrong reference.
I think you did.
That standard, and this is something that is mentioned in many of the cases that I've just summarised, is not coextensive with the national legal systems. That doesn't mean the same thing as our criminal courts mean when they talk about beyond reasonable doubt. It can follow from inferences, unrebutted presumptions of fact, and it's intrinsically linked to the specificity of the facts, the nature of the allegation, and the rights at stake.
Yes.
But the standard is always beyond reasonable doubt, and whatever that might mean, it plainly can't mean less than 50%. Proposition 2.
I beg your pardon, may I just ask, the level of persuasion required to reach a conclusion is intrinsically linked to the specificity of the facts and so forth.
Yes.
Is that your submission of inference again?
I think that must be said in respect of inferences. That must be what the court is saying in relation to inferences.
That's your submission as to how we should understand that paragraph?
Yes.
Yeah. Thank you.
Because it follows from the court's general proposition that it employs inferences in assisting somebody to meet that standard of proof. But you are never going to find anywhere in the Strasbourg case law any suggestion that the standard of proof is anything less than beyond reasonable doubt.
The appellant's written case doesn't condescend to analysing the specificity of the facts alleged in this case.
I can do, my lord.
Yeah.
But this is, so far as we see it, a pure issue of law, because the High Court found in terms that if we're right about the standard of proof, that the respondent hasn't met it. But if it's required, and perhaps my reply would be the best place to do that, we can engage with why it was that the High Court was right to reach that conclusion, and why it was on the facts that the respondent's evidence didn't come close to establishing on the balance of probabilities, or as Strasbourg would have it, on the beyond reasonable doubt, that there had been corruption in this case. My lord, my second proposition was that, torture evidence aside, Strasbourg has never suggested any standard of proof short of beyond reasonable doubt, and particularly has never done so in any case concerned with the enforcement of a conviction in the foreign sense. So those are cases like Söring and Drodz, which we have already looked at. Can I make this clear? Because to this extent, I think I agree with the respondent. Neither of those cases deal expressly with the standard of proof. They're very clear about the fact to be proved. Has there been an unfair trial? But they don't expressly address the standard of proof. That in itself, we say, is significant, because if they had intended to depart from what we've seen is the normal Strasbourg rule, beyond reasonable doubt, you can expect it to have said so, Söring or in Drost, and it didn't. And that's especially significant for Söring because, as we will see, or have seen, in that case, it did lay down a lower standard of proof for accusation cases. At paragraphs 91 and 87, it laid down substantial grounds for believing as the relevant standard of proof in an accusation case. So it was departing there from the norm, and it said so, whereas in its paragraph 113, dealing, albeit obiter with conviction cases, it didn't suggest any different standard of proof than the normal. But perhaps I can't and shouldn't take those cases very much further. But Strasbourg hasn't always been silent on this issue. Shamayev, paragraph 338 at page 4903, reiterates that even in the extradition context, when the court is called upon to establish past fact, it applies beyond reasonable doubt as the standard of proof. So, my lords, page 4903.
Which paragraph?
It's paragraph 338, my lord, and I'm just trying to catch up with myself. Shamayev is Authorities 79. It's an extradition case to Georgia. Page 338, under the heading General Principles, which begins at 333, the court reiterates at 338 that this is in the middle of the paragraph, about 7 lines down from the top of the page. In assessing the evidence, the court applies the standard of proof beyond reasonable doubt. Reasonable doubt is not a doubt based on mere theoretical possibility, but a doubt for which reasons can be drawn from the facts. So, not beyond unreasonable doubt, but beyond reasonable doubt. Hence, see paragraph 353 on page 4907. Court ultimately concluded that in light of the evidence in its possession, the facts of the case do not support beyond any reasonable doubt the assertion that at the time there was a well-founded ground to believe of a real risk. So what the court is doing here is looking at past facts for the purposes of informing future risk. The point is, even here, the court applies the beyond reasonable doubt standard. In fact, one of the arguments raised in that case was a pure past fact argument about whether one of the applicants had been killed during the process of his surrender to Georgia, from Georgia to Russia, page 4897. In paragraphs 320 and 321, the court records its doubts and fears that concerning Mr. Aziev's fates as legitimate. See last 2 lines. First 2 lines of 321. However, the evidence available does not enable it to conclude that he had died. So you see it in operation again. The fact is, when it's concerned with past facts in any context, even in the extradition context, it applies beyond reasonable doubt, and it applies that in practice. I've already dealt, I think, with my third proposition. If it means to say something else, such as substantial grounds for believing or real risk, it says so in terms. See Zering, for substantial grounds for believing being the appropriate standard of proof in the accusation context. See Othman, for real risk being the appropriate standard of proof in the torture context. But Othman itself is obviously instructive because, as the Court of Appeal rightly observed in XX, my Lord's page 3876 at paragraph 42, 3876, excess paragraph 42, concerning the same debate in A number 2, as Othman had engaged in, the fact that our courts, A number 2, Othman in Strasbourg, are debating where to set the standard of proof exceptionally in a torture case shows of itself, the very fact of that debate shows that something other than real risk must ordinarily apply. The exception proves the rule. So overall, on Strasbourg, where the fact to be proved is that the trial was unfair, the Strasbourg case law is clear, unless you're concerned with torture. The standard of proof isn't set down at the level of chance or possibility. It is beyond reasonable doubt. And there are obvious policy implications and reasons for not allowing the standard of proof to dip down to that level. Real risk is a low threshold. I think in the immigration context there have been suggestions that 10% chance is good enough to establish it. Certainly in the extradition context, a 5 to 13% chance was recently held to satisfy it. Real risk is not an exacting test. But there are practical difficulties, of course, in extradition courts addressing arguments about foreign trials. And Mr. Justice Davis, as he was in Wilcox, at paragraph 90, page 3785, set all those out and made clear that as a result the bar must remain high, paragraph 91. Similar observations were made by Lord Justice Toulson, as was in Sobchak, paragraphs 13 to 15, page 370.
Sorry, could we have it again, please?
Sobchak, 13 to 15, page 3709. And if you reduce the standard of proof in respect of past Article 6 violations, it's going to have to also work the same way for other articles. A past Article 7 violation would have to work the same way. For example, an argument that the trial involved some retroactive application of foreign law, you'd have to set the standard of proof for that kind of assertion at real risk. And you wouldn't just be confined to expulsion cases. The same test, past violation of Article 6, applies in all sorts of contexts. Damages in the domestic context. And applies there with the flagrancy threshold built in. There would be no reason at all, if real risk was the standard of proof here, why it didn't and couldn't need to be injected into Article 6 for conviction cases everywhere. Domestic context, foreign context, Strasbourg, our courts, or all of the beyond reasonable doubt cases that we've been looking at are domestic cases. The implications of lowering the standard of proof would be vast. And we say lie behind Strasbourg's insistence throughout on beyond reasonable doubt as the proper standard of proof for past facts. And it therefore shouldn't surprise us to see that domestic extradition law does the same. It's of a piece with Strasbourg's approach, save that here you read beyond balance of probabilities for beyond reasonable doubt, because that's what it means essentially in R. There are various cases that I could take you to, but the easiest, I suspect, will be Lezon. Page 1731, paragraph 22. Because the trial and appeal process had already occurred, it constitutes past fact. Thus, the question of whether it was flagrantly unfair, that's the fact to be proved, is susceptible of proof. In our view, in a situation such as the present, it is for the appellant to establish, on a balance of probabilities, that the process of which he complains had in fact been flagrantly unfair. That accords with long-established general principle. And it does, of course it does, because that's what Strasbourg says, and says repeatedly.
This is Lord Justice Aikins.
This is, yes. And this is Lord Justice Aikins responding specifically to an argument that real risk should be the appropriate standard of proof. In Caderly, page 1718, paragraph 55, Mr. Justice Chamberlain recently arrived at precisely the same conclusion. The appropriate standard of proof should be, and always has been, balance of probabilities.
The page number?
That would be 1718, paragraph 55. The simple fact is there is no UK authority whatsoever that supports the High Court's approach in this case, outside the realms of the special rules that apply to torture. None advocate risk, chance, or possibility as the appropriate standard of proof for establishing past fact. So what is there then that led the High Court to do what it did? And here we're assuming that all it did was adjust downwards the relevant standard of proof. Well, there was the Irish decision in Rostas. The position here, I hope, is reasonably straightforward.
Are you addressing us on your fourth proposition? We're doing that later. Your fourth proposition is ultimately the very fact of the exercise in Othman shows that something else higher otherwise applies.
I thought I had addressed my lord on that. That's XX paragraph 42.
That was XX.
It's the point that the Court of Appeal made in that case.
Sorry. Yes, I thought you were going to refer to Strasbourg jurisprudence, but you're using that summary. Thank you.
I think that's probably the easiest way to make that forensic point, which is if the standard of proof was generally only real risk, then there was no need at all for Strasbourg and Othman to try and to be talking about whether it should come down to the level of real risk in a torture case. That's the essential point made by the Court of Appeal in XX.
It's in the middle of paragraph 42.
Yes.
Yes, I see. Thank you.
So just to recap, the review of the Strasbourg position was beyond reasonable doubt, never suggested otherwise. Where it says otherwise, it says so. And ultimately, the fact of the exercise undertaken in Othman for torture shows that the general rule must be higher than real risk. And we went through all of those. I then turned, my lord, to the domestic position, which arrives at precisely the same time as this. And I'm turning now, if I may, to Rostas, which is the Irish decision which caused the High Court to do what it did in this case. Some brief history, please, for Rostas, so that you can understand exactly why Rostas went wrong. Before Rostas, the position was clear. Page 2863 is the judgment of Mr. Justice Edwards in a case called Marjaz in 2012. The last 4 paragraphs of that page, and over the page down to just below the second hole punch, contain a correct and uncontentious summary of the relevant law. In respect of a complaint, so this is 4 paragraphs up from the bottom of 2863, that the trial leading to a conviction which is the subject of a European arrest warrant was unfair. The court says this in the middle of the penultimate paragraph: if it is inevitable that a person will be deprived of their liberty on surrender, that is the forward-looking Article 5 risk, and it has been demonstrated by compelling and cogent evidence that the conviction underpinning that sentence was the result of an unfair trial, then it could be said that the act of surrender would expose the respondent to a breach of his right not to be deprived of his liberty. That's entirely conventional and unobjectionable. Penultimate paragraph, the court considers that it's theoretically possible for somebody to suggest that an extant conviction was the result of an unfair trial. This jurisdiction is likely to be exercised very sparingly indeed, and only in cases where it is established by the clearest and most cogent evidence that there was a truly egregious unfairness. Egregious, of course, is flagrancy. So the court had it right, and it understood the relevant principles. But then came my Lord Othman in Strasbourg, paragraphs 258 to 261. And you will find those, my Lord, on page 2603 of the electronic file. Othman was an accusation case because Mr. Othman was facing a retrial in Jordan, and the court set out the general test that should apply to his case, and it's uncontentious. It's the usual real risk, substantial grounds for believing, real risk of a flagrant denial of justice upon surrender. In paragraphs 258, 259, 260, 261, the court addresses the unexceptional and obvious test that applies in the accusation context. It deals with flagrancy at 259 and 260, and at 261 deals with the standard of proof that should apply. And because that was an accusation case, it is for the applicant, that is, that applicant, to adduce evidence capable of proving substantial grounds for believing a real risk. There's nothing revolutionary about that. That is the test that applies in an accusation case. But when the matter then came back before the same Irish judge in Rostas, and this, my lord, is your page 2890. Two years later, the same judge was faced with another conviction case where the defendant was arguing my trial was unfair. The judge took those passages from Othman and believed wrongly that they required him to use that same test in a conviction case. The operative part of the Rostas judgment begins at paragraph 87, page 2890, and starts off okay. Paragraph 87 is the Marjaz test. Paragraph 88, the starting point, is the great reluctance. The court should be slow to embark on any inquiry. In an exceptional case, an inquiry may be appropriate. So far, so good. But then, paragraph 89 to 92, it all goes wrong. The judge takes Marjaz, the correct test for a conviction case, and believes that it needs to be modified in light of Othman. Well, it didn't at all. Othman was an accusation case to which completely different principles apply. But what it did, it thought, paragraph 90, that those paragraphs, 258 to 261 of Othman, also applied to conviction cases. They didn't. And so at 92, you have the core of the problem that confronted the High Court in this case. The High Court in Ireland decided that it had been told by Othman to lift the accusation test and supplant it onto conviction cases. Nothing of the sort had happened at all. And so what the Irish court ends up doing is creating this strange test with two standards of proof, according to the respondent, whereby there must be substantial grounds for believing that there is a real risk that the respondent suffered a flagrant denial of justice. That's where this all went wrong. And it went wrong because the Irish court wrongly thought that Othman had told it to lift the accusation test and just supplant it onto conviction cases. And that authority from the first instance court in Ireland was the core foundation for the respondent's submission to the High Court in the present case. In fact, the submission about real risk and standards of proof wasn't even being advanced until on the afternoon of the day before the hearing in the High Court. The respondent stumbled across that Irish first instance decision and added it to the bundles and produced submissions in relation to it. It was the only relevant decision to which the respondent drew the High Court's attention because it was the only possible decision that he could have drawn the High Court's attention to. No other case contemplates lifting the accusation test in that way and just plonking it down onto conviction cases. Unsurprisingly, those paragraphs, 89 to 92 of Rostas, have been routinely ignored for the nonsense they are by the Irish courts ever since. Lipitov's paragraphs 39 to 40, page 28.
Sorry, the name of the case?
Sorry, Lipitov's.
Yes. Reference?
Paragraphs 39 to 40, page 2854. in a series of cases which all say exactly the same thing, Mrs. Justice Donnelly takes the usable bits of Rostas, that is everything up to paragraph 87, and nothing else.
It is odd because in paragraph 90 in Rostas, the judge makes it quite clear he understood that Othman was concerned with an accusation case.
But he
and then he quotes from Othman, and then says it has to be his Marjaz test has to be modified without any explanation.
And it's quite difficult to understand what's gone on here.
Yes.
But being as generous as I can be, the judge appears to have believed that even though it was an accusation case, Othman was saying the same test needs to apply in conviction cases, and of course Othman says nothing of the sort. No doubt if the Donnelly authorities had been brought to the High Court's attention, they would have done what she did, which was leave Rostas in the past. So that's Rostas. It was a supremely unsafe foundation for the High Court to do what it did, and yet it was the only foundation for the High Court doing what it did. So what else is there? It was no part of the High Court's reasoning that there should be some form of extension of the test that Strasbourg applies to torture evidence. Torture evidence is the only area countenanced in Strasbourg where the standard of proof for past facts is lower than normal. And it's crucial to understand why. This is an extraordinary branch of the law, not capable of being picked up and transplanted onto all other aspects of Article 6. There are a number of obvious reasons why that is so. First, it derives from a particular Jus Cogens absolute international prohibition. Special rules apply to torture. It has a special stigma in law. And even Othman spoke about its unique legal status. Secondly, it is a norm which gives in turn to a particular evidential rule of admissibility in international law, which derives from a particular external legal source, namely Article 15 of the UN Convention Against Torture. That is an international rule of admissibility whose parameters are rigid, at least at the international level. Thirdly, it is a rule which rests on principles which are not, or at least not totally, concerned with the fairness of the trial. They are concerned instead with the integrity of the court's process, its moral integrity. Fourthly, when operated as an admissibility rule in the convention sphere, it does so as an express exception to the usual rule that Strasbourg is unconcerned with admissibility at all. And fifthly, to animate...
Sorry, your fourth point is when Strasbourg...
my fourth point was when this strange admissibility rule, I say strange, of course, I don't, it's not pejorative, but this unique admissibility rule operates in the convention sphere, it does so as an exception to the usual rule that Strasbourg is not concerned with admissibility.
Before we go on to your fifth proposition, could you repeat your second, please?
My second was, first was absolute prohibition on torture. Second was, it's a norm which gives in turn to a particular evidential rule of admissibility in international law, deriving from a particular external legal source, namely Article 15 of the UN Convention. And it's a rule whose parameters are, at least in international law, rigid.
Thank you.
Third, rests on principles which are not, at least not totally concerned with the fairness of the trial. They're more concerned with the integrity of the process. Fourth...
Yeah, I got 3 and 4.
Forgive me.
Yes, thank you.
Fifthly, then, to animate all of that unique admissibility rule deriving from a unique source, Othman developed, or set about developing, another exception to Strasbourg principles, namely the general requirement to prove past fact beyond reasonable doubt. And it did so by way of reasoning that doesn't extend out into Article 6 past facts more generally. The rationale for lowering the standard of proof here is confined to the particular and exceptional characteristics of torture evidence. And it is found in paragraph 276 of the Othman judgment at page 2608.
2608.
2608. So we already looked at paragraph 273. That's the test it arrives at. Its reasons are threefold. The first and second are concerned with the notion that the court isn't bound by any previous domestic state authority. The most important and the key reason that Strasbourg departs from the usual standard of proof in this particular instance is to be found in paragraph 276. And this is where we come to my Lord Kitchen's issue on inferences. Due regard must be had to the special difficulties in proving allegations of torture. Torture is uniquely evil. I have underlined the word uniquely, for both its barbarity and its corrupting effect on the criminal process. Practiced in secret, interrogators who are skilled at ensuring it leaves no visible signs, courts, prosecutors, medical personnel are complicit. In a criminal system where the courts are independent of the executive, where cases are prosecuted impartially, where the allegations are investigated, one might conceivably require a defendant to prove to a high standard that the evidence had been obtained by torture. However, in a criminal system which is complicit in the very practices that seeks to prevent, such a standard is wholly inappropriate. That is the court's reasoning for applying a lower standard of proof. And it's important to understand what the court was talking about.
I think Lord Kitchen was on a slightly different point, and that was that there was an inference available even if there was a higher standard of proof. And all this does is establish a lower standard of proof.
Thank you.
Yeah.
What made the Strasbourg court do what it did in the special instance of torture is the fact that torture corrupts power. For it to be practiced at all, the state itself has to be complicit in it. It can't operate as a practice if prison doctors are watching, if prosecutors are undertaking meaningful investigations, if the courts are doing what they are there for. In short, for it to operate at all, it has to be the result of statewide complicity and concealment. The way...
You say torture corrupts power, but it's not really that. It is that if a state practices torture, it is corrupt.
But the whole state...
The whole state is corrupt, yes.
That's the key.
The executive, the prosecutor, the justice system.
Yes. And the point that Strasbourg is ultimately making is that this isn't equatable to the general situation where an event is simply difficult to prove or substantiate because the facts are within the knowledge of the state. The general response of Strasbourg to that problem, and this is, I hope, is my Lord Kitchen's point, is to invoke inferences, presumptions of fact, which help a defendant overcome the standard of proof. They don't adjust the standard of proof normally. They develop and have developed, as we have seen, normal, recognizable principles surrounding the drawing of inferences. Gafgen, paragraph 92, we've already looked at.
Sorry, which case?
Gafgen, paragraph 92, page 4311. The standard of proof remains the same in a normal case. And there are principles that assist any given defendant, faced with facts which are largely within the knowledge of the state, to reach that standard of proof. They're the usual principles that we're all familiar with surrounding inferences. So if one turns to, and we could turn, frankly, to any of the cases on inferences, but let's look at Krianga, paragraphs 89 to 90. This is page 2336. '88 down to 90. This is one of those cases, and there are lots of them, where the facts are just difficult to prove because they lie inherently within the knowledge of the state, not the defendant. The court's normal response to this problem is, firstly, to reiterate that the standard of proof remains fixed and immutable. But then to reiterate that it will adopt conclusions, middle of paragraph 88, that are supported by a free evaluation of the evidence, including such inferences as may flow from the facts. Paragraph 89, line 4, for example, where the events in issue lie within the exclusive knowledge of the authorities, as in cases of persons under their control in custody, strong presumptions of fact will arise. And the burden then is regarded as resting on the authorities to provide a satisfactory and convincing explanation. And if you don't, that itself is evidence which the court will feed into its assessment in determining whether the claimant has passed the relevant threshold, whether he has established beyond reasonable doubt. And all of the court's principles on this, about presumptions of fact, onuses for explanation, once there are concordant inferences, all of that, see paragraph 90 as well, prima facie concordant evidence capable of showing something, then you require the government to respond, and failure, bottom of paragraph 90, enables the conclusions to be drawn as to the merits. That is normal, conventional operation of inferences. Conversion of a prima facie case into proof on grounds of inherent probabilities and the like.
And that's the same in any case?
Yes, absolutely. Now, those are the normal principles that Strasbourg applies, and you would see it in my learned friend's favourite case, Merabeshvili, at paragraphs 311 to 313, etc.
What page number is that? Sorry,
Merabeshvili.
Page number, sorry.
2477, my lord.
Thank you very much indeed. Okay.
Normally, Strasbourg doesn't adjust the standard of proof. It reiterates and reiterates time and again it's beyond reasonable doubt, but it affords the party seeking to meet it mitigating evidential tools by which it more readily may do so.
Conventional tools?
Yes, absolutely.
Yes, it'd be absolutely standard if someone goes into a police station uninjured and comes out injured, it's not very difficult for a court of law to infer that something untoward has happened within the police station.
Absolutely. Standard, inherent probabilities, inferences, TC cums, all the rest of it. And it's not just in Article 2 and Article 3 cases, or even Article 5 cases where this works. You see it in Article 10, in Article 18. In all of the cases, Strasbourg's normal and conventional response to this problem is don't move the standard of proof, but you employ inferences. You assist somebody in the exercise of compiling their evidence to get over the line. You don't move the line itself. Now, that logical exercise works in the generality of cases because it's premised on trust in the state's response. You can trust a state normally to provide the footage of its detention centre, and if it doesn't, you can infer something strange has happened. But the problem which confronted the Strasbourg court in Hoffman was a different one. That approach doesn't work in torture cases because they're every organ of the state to whom one would ordinarily turn for proof are themselves complicit in the practice of torture. Its unique corrupting effect means that you can expect a false denial in every case. Inferences are worthless. What's the point in asking Jordan whether they tortured or not? To that exceptional problem, the solution of the Strasbourg court therefore had to be more radical. It couldn't just employ inferences as it normally would. It had to do something different, and that was lower the standard of proof. At least, see paragraph 276, for those cases where the state is corrupted. The fact that that doesn't apply, according to paragraph 276, where that's not the case, shows that that is the reasoning that underlies Hoffman itself and that it's determinative. And ultimately, we, the appellant, have no issue with that exceptional approach in that exceptional case. But it's not reasoning that extends out more generally into proof of past facts in the Article 6 sphere. To all other cases, and to torture cases where the state isn't corrupted itself, the normal rules are entirely workable, and the view of this court in A number 2 remains entirely compelling. The majority of this court, even in the realm of torture, would have imposed balance of probabilities as the requisite standard. For Lord Hope, it was crucially because risk is to do with future events, not to past. For Lord Roger, it was because reducing the standard of proof down to below 50% reverses it and inverts the true rule.
Are you suggesting that an inference can't be drawn in this case? That it is impermissible to draw an inference from the silence of the state to the accusations that have been made?
I am suggesting that the proper approach to the High Court and the approach of the Strasbourg would take is to draw inferences, right, if appropriate. Okay,
right. And but you haven't made any submissions about whether it is or isn't appropriate in this case to draw.
Can I do that now? I wasn't intending to. I was planning to leave that to reply, but can I set out our case? Our case on whether it was or wasn't appropriate to draw inferences against Romania on the basis that they had failed to account for the judge's corruption, as alleged, is that, firstly, there were no inferences that were proper to be drawn. Romania wasn't silent on this issue at all. If you look at its response, and this is page 369 of the bundle, it's Appendix 1. page 369. This was Romania's response. The first paragraph deals with... Well, let's start at page 368. Bottom paragraph. Romania's response to the allegations were, neither the case prosecutor nor the hearing prosecutor was aware of the existence of any such friendly relationship. The National Anti-Corruption Directorate, that's the whole prosecuting authority, did not have information about a possible hiding by the judge of such a relationship. That is the bit on which the High Court and the respondent focused, but it didn't, with respect, end there. Over the page, Romania said this. First paragraph deals with prospective remedy, and I'll come back to that. But it added this, regarding the two witnesses involved, that's Mr. Dumitrescu and Mr. Dejana, checking the database managed at the level of the National Anti-Corruption Directorate, it turned out that Mr. Dejana is being investigated himself for corruption. And what's more, following a denunciation formulated by the judge's son back in 2013, which is currently itself under investigation, and that investigation was for tax evasion and money laundering. Romania wasn't being silent about the allegations. It was saying, we don't know what you're talking about, and what's more, we don't believe that the witnesses that is being relied on, Mr. Dejana, is somebody you should be trusting. Firstly, he's under investigation for tax evasion and money laundering, but most importantly, the reason he is under investigation for tax evasion and money laundering is because the judge's son had denounced him. That's a motive to lie. So Romania wasn't admitting that the judge was corrupt. It was doing precisely the opposite. It was making clear that it didn't accept that the judge was corrupt. It's got no information to support that. And the sole witness who was saying it, or at least the sole witness prepared to give live evidence who was saying it, had an obvious and clear motive to lie. So firstly, my lord, we don't accept that Romania was silent. Secondly, if it was silent, it had entirely good reason to be. If you look at the next response that emanated 3 days later from Romania at page 372, where it deals again with the investigation launched by somebody called Cesar Penate, Mr. Dejana's client, in which all of this is being litigated and aired in Romania.
Where are we looking?
We're looking at the bottom of page 372. Roman 3 is where this issue begins, dealing with case number 1603. That's where all of this evidence emanates from, or at least most of it. The court makes clear what the investigation is, what stage it's reached, and then at the bottom makes clear that from the discussions with the case prosecutor, it resulted that he cannot set a deadline for the completion of the investigation because he has to administer all the evidence in the defences formulated by the judge. What Romania was also saying was, we can't say anymore because it's sub judice. It's a fallacy to draw an adverse inference if there is an explicable or understandable reason for silence on any issue. See Lord Lowry in T.C. Coombs. So firstly, Romania wasn't silent. It was obviously contesting the suggestion. And secondly, insofar as it could have said more, it had understandable reasons. So ultimately, We don't accept that the High Court should or could have invoked inferences against Romania in this case, but I have to accept that it did. Paragraph 163 of its judgment. According to the High Court, the respondent has failed to put forward any evidence or information which dispels all the concerns. This is the language of inferences.
So the page number
163 on page 198. So it's clear that the High Court did draw weak inferences against Romania to assist the respondent in its effort to discharge the standard of proof required of him. But the end result was those inferences were not sufficient to carry his unhappy evidence over the threshold of balance of probabilities. See paragraph 162 in the middle. Cannot conclude on the balance of probabilities that the allegations are true. So I hope my answer to my Lord's question is clear, but it's one, we don't accept that Romania should have been the subject of inferences in fact. It was clearly denying the corruption, and for good reason. Secondly, it had in any event good reason to not say any more. But I have to accept that the High Court took a different view, and it did draw inferences against Romania, but they weren't of sufficient cogency or weight to carry the respondent where he needed to be. And that is, with respect, an entirely proper approach to inferences. They have some weight. In some cases, they have great weight. In other cases, this was a weak inference which didn't take the respondent very far. So we say, coming back, my Lord, if I may, to inferences, which is how Strasbourg would approach any case apart from torture, and how the High Court appears to have approached this issue. The framework of inferences was the correct prism through which to view all this, not playing with the standard of proof. And the High Court, although we don't agree with how it ended up where it did, at least was right to conclude that the inferences in this case were not weighty. So, my Lord,
where did you find that?
Paragraph 163. It's clear that they were drawing some inference, but paragraph 162, not of sufficient weight to carry the respondent over the balance of probabilities.
They certainly don't analyse the strength of the inference, do they?
Well,
they don't go into the detail.
That may be right, but we say there's probably a good reason for that, because it wasn't really a very strong one. But it doesn't really matter, because it must be clear from the result that the inferences it was prepared to draw weren't weighty, or at least weren't sufficiently weighty to carry the respondent up to the required standard of proof. They were sufficient to carry him up to the level of real risk, if that's the standard of proof that was being applied, but not balance of probabilities. And we say that there are obvious and sensible reasons why the inference, or any inference, from the state's silence in this case was not a weighty one. But coming back, if I may, to Othman, when we understand why the Strasbourg Court did what it did for torture cases in particular, we can understand that it's not a principle that can be extrapolated more widely into Article 6. But that is, of course, precisely what the High Court did. It broke down the careful barrier that Strasbourg has erected between torture evidence on one hand and everything else on the other hand, without saying so, without considering the broader policy implications of doing so. And it's not without note that paragraph 265 of Othman itself records the Strasbourg court's view that there is, quote, a crucial difference between a breach of Article 6 because of the admission of torture evidence and, on the other hand, breaches of Article 6 that are based on simply defects in the process or in the composition of the trial court. It is clear that Strasbourg wasn't intending to lay down any rule of wider application. And yet, the respondent suggests to this court that it should, of its own volition, forge some comparable special rule for judicial bias. There is no trace of any such exception in any case law anywhere. And we suggest there are three core reasons why that is so. One, the particular concerns that animated the court in Othman at paragraph 276 don't have any purchase here. The existence of one bent judge doesn't corrupt the entire state process. The state's evidence can be trusted, and the usual rules that surround inferences are capable of working properly. Two, we've seen that Othman expressly says there is no wider principle applicable, for example, to problems with the composition of the trial court. And three, no doubt all of that is within the contemplation of Strasbourg, because there isn't any similar kind of absolute Article 6 outlawing of bias in all its forms. There isn't some Jus Cogens prohibition on judicial independence. To remind, torture is without more and in every instance a flagrant violation of Article 6. Not so allegations of judicial bias. There are some problems that surround judicial independence that don't strike at Article 6 at all. Military judges, for example. There are some which, whilst they engage Article 6, don't do so flagrantly. In Droz, one of the Andorran judges was the joint head of police. That apparently wasn't a problem for the Strasbourg court. In Orobator, Lord Justice Dyson, as he then was, drew together a whole series of cases which fell on the non-flagrant line of judicial bias at paragraphs 86 to 99.
Where do we see that?
That would be page 3, 4, 5, 6. I don't think it's necessary to go through them, but the point is, not every problem with judicial independence is either a breach of Article 6 at all, or, if it is a flagrant one. There is, accordingly, no hint of the kind of rule for which the respondent contends. That is to say, a lower standard of proof whenever there's a problem with the composition of the trial court. There is no hint of such a rule in the Strasbourg jurisprudence. And the risk of making another jury point, Othman itself is proof that there can't be such a rule. Remember, please, that the Jordanian courts, according to Strasbourg, fundamentally lacked independence. If Mr. Fitzgerald is right, and of itself that is sufficient to operate or trigger a lower standard of proof, why did Othman and Strasbourg have to bother itself with engaging with torture evidence and what that court might do with torture evidence at all? The standard of proof was always, if Mr. Fitzgerald is right, down where he needed it to be. Of course it isn't, because Strasbourg recognises no such rule. Now, I accept that the principle of judicial impartiality is fundamental, it's cardinal, but it doesn't answer the question as to what standard of proof is necessary to prove that a judge was in fact partial or corrupt. To that, Strasbourg applies the ordinary standard of proof to fact-finding in relation to bias. Likewise, in a domestic case, the Court of Appeal wouldn't allow any conviction simply on the possibility that a judge was corrupt. They would establish whether he was or not, and then assess whether that proven corruption satisfied the legal test for bias, whatever it happened to be. That's the point made in Caderly at paragraph 52, page 1718. Can I then just deal, please, with another argument that, and I hope briefly, that Mr. Fitzgerald mounts. He says, well, Strasbourg doesn't appear to impose burdens of proof at all, from which he infers that there can't be any such thing either as a standard of proof. Of course, that reasoning is entirely flawed. Whatever Strasbourg does and says about the burden of proof, it uniformly applies beyond reasonable doubt as the standard of proof, except, of course, in torture evidence. You can see this clearly in play by reference to the respondent's favourite case, Merabishvili. So can we've only been to it, I think, briefly. Page 2477. Paragraph 311.
Sorry, bear with me a moment, if you would, please.
Sorry, my lord.
Entirely my fault. Yes, thank you.
The Strasbourg approach to burdens of proof is summarised entirely fairly at paragraphs 311, 312 and 313 of this Article 18 judgment. You could find this, frankly, in any Strasbourg case, but it's all summarised here. The burden of proof, as a general rule, this is 4 lines down into paragraph 311, is not borne by one or other party because the court examines all material before it, irrespective of its origin. Although it does observe a few lines afterwards, it has since then relied on the concept of the burden of proof in certain particular contexts. There we are. At 312, the court routinely, on its own motion, asks for material and draws inferences. 313, it'll often do that in cases in which the respondent state alone has access to information capable. That's entirely conventional burden of proof. But it doesn't equate to some free-for-all, unconstrained by any standard of proof. What Strasbourg Court does as a supranational court is to receive any evidence brought to its attention by any party, or indeed uncovered by the court itself. And from that body of evidence, it will, nonetheless, determine whether the allegations are proven to the requisite standard. And that standard, see paragraph 314, is beyond reasonable doubt. Employing such inferences as it deems appropriate to the facts. It does not follow from the court's general approach to burdens of proof that there is no standard of proof. The standard of proof is beyond reasonable doubt all the time, as it would be in a Porter and McGill situation. The burden of proof will be on a defendant to raise some evidence. The court will then inquire and determine for itself whether the allegations are proven. And if they are, and only if they are, will it then apply the law concerning bias to those proven facts. What doesn't flow from its flexible approach to the burden of proof is any variation of the standard of proof. So the argument with respect doesn't work at all. Can I turn, lastly, to the respondent's suggestion that the absence of a future remedy in Romania should somehow inform the standard of proof to Article 6 in his case. Of course, the court knows well that Romania's evidence before the High Court was there is no prospective remedy as a matter of Romanian law that will apply post-surrender. And the respondent relies on that. And for these purposes, I don't seek to go behind that evidence on grounds of procedural fairness. It turns out not to be correct, but I'm happy to be held to it on grounds of procedural fairness. Of course, on any view, the respondent does have multiple remedies to redress any proven violation of Article 6, because his surrender here is to within the convention space. He will have access to Strasbourg itself, a point made forcefully by Lord Justice Toulson in Sobchak. Which, to remind my lords, is page 3706. He also, through his flight to this country, possesses remedies in the UK extradition decision. He just has to surmount the usual conventional standard of proof, balance of probabilities. The existence, or otherwise, of a future remedy in Romania has no logical link whatsoever to the truth or otherwise of his allegations of historic Article 6 past facts. They happened or they didn't. It doesn't matter whether a court in Romania is going to action them or not. And I don't understand that Mr. Fitzgerald will suggest that they do have any logical link to this backward-looking Article 6 factual question. Was there a fair trial? The existence of a future remedy in this case, if it has any relevance at all, goes to whether or not the respondent will be imprisoned in Romania on surrender. That is to say, the other fact to be proved, the real risk of imprisonment on return. And on that, as we've discussed, that he's free or would have been free to make any point he wished about remedies. It's a fact, an issue of foreign law, capable of informing an assessment of future risk, that he may, if he has no remedy, or may not, if he has a remedy, in fact be exposed to a deprivation of liberty in Romania. But we saw, when we looked at this through the lens of Pierce, that he's able to rely on this issue of foreign law, whether he establishes it to the burden of the balance of probabilities or not, because it's a fact informing a future risk assessment. But on the present case, on the state of the evidence before the High Court, everybody assumed he had no future remedy. No suggestion that extradition would not expose him to the consequences of his sentence here, which allowed him to satisfy the Article 5 aspect of the Offman test. But it had no bearing whatsoever on the Article 6 aspect of the Offman test. And I am content for that position to remain. The respondent's case fails, or should have failed, not because he had failed to prove a risk of future detention, but because he had failed to prove to the requisite standard a past breach of Article 6. Future remedies have no bearing on the latter. My Lords, I lastly intend to turn to the alternative case that the respondent now makes under Article 5(4). That is the case that even if the High Court was wrong about how it approached Article 6, and he hasn't satisfied the burdens that rest on him, he still faces, he says, a standalone risk of a future violation of Article 5, sub-Article 4, because there will be no Romanian court that will ever look at the legality of his continued detention by reference to new facts which have emerged. My Lord, it's going to take me more than 4 minutes to address that, and I wonder whether that would be an appropriate moment to pause.
Yes, well, you have more than 4 minutes after the short adjournment.
I do, and I'm certainly not going to need it all. So I don't.
Yes. Well, in that case, the court will adjourn now for the short adjournment. Thank you very much.